Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Amanda Fetter presenting for us. If you are unfamiliar with the format of this event, first, Amanda is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Amanda will go over this in more detail, but please remember to keep your questions as general as possible as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will not take any more questions after 4:20, and we'll have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Amanda to get us started.
Can you hear me?
Yes.
Okay, great. Hi, everybody. My name is Amanda Fetter. As Marissa said, I'm a housing attorney with Legal Aid and have been for a few years now. Also, as Marissa said, this is a public forum, so you want to be careful what you share. And also, I can't answer questions about any one specific case because that's not the type of relationship we have going on here during this talk. This is general information for everybody to take in and can ask general questions at the end. So we're going to go ahead and get started. Okay, so first, this is Legal Aid of North Carolina. We do more than just housing. As you can see, in limited cases, we handle other types of law, litigate other types of law. We also have listen and learns, like this one for other benefits. If you go to our website, Legal Aid of North Carolina, there's just a ton of other resources like this one. So check it out. All right, so just starting with the basics in terms of who's actually a tenant. If you are just staying with somebody as a guest and you're not paying anything or there's no agreement for an exchange of something, then you're just a guest and you're essentially being given the gift of a place to stay. You're not officially a tenant until there is a landlord-tenant relationship or a contractual relationship between you and the owner of the house. So you give the landlord something in exchange for the right to possess or stay in during that time your rental home. And we'll talk more about that shortly. If you are a tenant legally, as I described, then you cannot be dispossessed or put out of the home without the landlord going through the eviction process. Of course, we're going to talk about the eviction process. If you are not officially a tenant, and let's say you're staying with a friend and that friend says, okay, it's time for you to go, you do not have to, or they do not have to go through the eviction process. If you don't leave at that point, you're just a trespasser. We're also going to talk about repairs and rent abatement. We're going to talk about the landlord's responsibility is in terms of keeping the house or apartment in a habitable condition, and what your options are if the landlord's refusing to do that. And we're also going to talk a little bit about security deposits. Legal Aid doesn't typically handle security deposit cases, but they're actually not too difficult to file yourself if your landlord is refusing to return your security deposit. So we can talk about that as well. All right, so as I said before, a tenant is someone who has a lease with a landlord. So as most people know, usually is a written lease with lots of terms, but the main terms will be the amount of rent and the lease term itself. So not every lease has to be in writing. There are many leases that are just verbal. Say, hey, look, you pay me $500 a month. I'm going to let you stay here. That is a lease. Once you pay, you have the right to stay. And again, that would trigger the eviction process if the landlord wanted you out. But you've got to be giving something in return. It doesn't have to be a set amount of money. It can be, I agree to pay the utilities, or I agree to do maintenance on the house. In those situations, it does need to be pretty explicit in terms of what you're doing around the house, what what you're giving. Otherwise, it could be construed as something other than a lease. But typically, if there's an agreement in exchange for X, I get Y, that sort of thing. And if you're living in a hotel, there are certain situations in which you would also have a right to the eviction process if the owner of the hotel is trying to terminate the tenancy. But in a lot of or in some circumstances, you are a tenant if you're in a hotel as well. Okay, so as I said before, if you are a tenant under North Carolina law, the landlord cannot just tell you to leave and then call the sheriff, or if you don't, or throw your stuff out, change the locks. That's an illegal eviction, or a constructive eviction, or a self-help eviction. That's another way to describe it, and that's illegal. So if you have a lease, and even if you didn't pay your January rent, let's say the landlord says you didn't pay your January rent and it's, what's it, the 21st, get out and change the locks. That's illegal. And if that happens, then you're going to want to call legal aid right away and talk to us about that. But most landlords know that there is a process that they have to go through before they can legally take back possession. Until there's a final court order that says the landlord is entitled to possession. And then we'll talk about padlocking later. You have the right to remain in possession of that home until court order says otherwise, regardless of the circumstances, if you are a legal tenant. All right, so most terminations of tenancy or the end of tenancies begin or must begin with notices to vacate. So it doesn't technically have to be in writing. Well, the thing that controls is your lease. If you have a written lease, that's where you're going to want to start with any landlord tenant, any housing questions that you have. That is the most important document. It's the first thing we will ask to look at because it has all the rules of your tenancy. Read every single lease before you sign it, top to bottom, start to finish, frontwards, backwards, everything. If you have questions, ask your landlord if you need clarification, because it's not just a piece of paper, it is the piece of paper. So in terms of what you think your landlord is required to do, or vice versa, you're going to want to look at your lease. And let's talk about written leases for now. Okay, so you have a written lease that controls. So that's the first place you're going to look. If there is no written lease, it's an oral lease and you still have a lease, but instead of having written rules, you would go to North Carolina law to see what the requirement of landlord and tenant may be. So if you have a lease that says the landlord must give me at least 30 days notice in writing if they do not want to rent to me for the next month. So let's say February. Let's say you're on a month-to-month lease, meaning you just go from month-to-month tenancy. If the landlord doesn't want to rent to you in March, then the landlord has to give you sometime before the end of January notice that come March 1st, you need to be, or come February 28th or 29th, whatever, you need to be out. They have to give you the opportunity to move out before they file an eviction. They can't just say, well, I want you out, and then turn around and file an eviction the next day. So again, your lease is going to describe the way that the notice must be given. And it also usually details a number of days that you have to move out. It actually works the same way the other way. If you didn't want to renew your tenancy for another month, for the month of March, that lease may also say, likely also says, tenant must also give 30 days notice if they don't want to renew. So which means that you would also be required to give the landlord notice that you do not intend to be there or pay rent on March 1st. And then they can't, as long as you give the proper notice, they can't hold you accountable for any other months after that may be. But again, it's what your lease says. So again, the landlord has to give you that opportunity to move out. And let's say that you do. Let's say you get the notice. Let's say you get it today that says, I'm not renewing your tenancy as of March 1st. Then you've got 30 days to, get everything out, return it to the condition that it was, other than wear and tear, and return your keys. At that point, and you do have to continue paying rent when you're there. So again, let's use our example that you're supposed to be out by February 28th. It doesn't mean that you don't have to pay February rent. If you are there, unless it is explicitly waived by your landlord, you have to pay it. If you get a notice saying, I'm terminating the lease in 2 months, and you say, okay, well, I've got to save that money so I can move, that's a decision that you can make, but you are subjecting yourself to an eviction for non-payment for not paying those months. So just because they're terminating the tenancy as of a specific date doesn't mean that you don't have to pay rent the rest of the time you're there. But if you paid February rent, moved out, turned in the keys on February 28th, assuming it's not a leap year, which I don't think it is, then you would be in compliance with all of that. You pay your, and then of course we have the security deposit, which we'll talk about later. It only comes up after you move out, the security deposit that is. So that's why we don't talk about it at this point. Let's say that you paid February, landlord filed on February 21st, saying, but then you didn't have court until March 1st. They filed too early. They say you have until the 28th to move out. They cannot file before that. We'll probably circle back to this shortly. Okay, so let's say that you're unable to move out by the 28th. Let's say you paid the rent on the 28th, but you couldn't find a place to go. And you're like, well, I'm really hoping that they've changed their mind and I could just stay at in March. Our general recommendation for stuff like this is if you're on a month-to-month tenancy like that, and you're just thinking, well, I can't move out by February, but I know I can pay March, you can offer March rent to see if the landlord will accept it and renew that tenancy despite the notice for another month. If they accept it, then you're good to go for another month, and they would have to send you a new notice to vacate if they didn't want to continue it for the following month, and so on and so forth. Their other option is to say, I don't want the March rent, I wanted possession, which is what I want. Kind of circular, but anyway, so at that point, they can file an eviction asking for possession. And they're not necessarily saying that you've done anything wrong other than holding over, which is the term for when they asked you to leave at the end of a lease term and you didn't. They're taking you to court for holding over. You could be the best tenant in the world, and they still have the right to take you to court for holding over because they followed the terms of the lease and or North Carolina law, and gave you the opportunity. And at that point, their next course of action would be filing an eviction. And again, they don't have to accept that March rent. And if they do, they're kind of screwing themselves over because they are stuck with another month tenancy. So a lot of landlords will say, no, I don't want that. I want you out. So you've really got to abide by that notice to vacate if you want to avoid an eviction filing. Once an eviction is filed, it does public record, shows up that it's filed. And if you are looking for another place to move to, chances are that's going to pop up and could be a problem. So holding over really should be a last resort. And I would recommend staying in touch with your landlord if you think you might have to do that or trying to work something out. All right, so again, you're unable to move out, you get an eviction filing. So what that looks like is it's two pieces of paper. There's a long ways. It's called the summons, and that tells you where and when the court date is. And the complaint is the landscape version of the paper behind it. It says complaint and summary ejectment, and that's where the meat of the cause of action is, because it tells you why and on what basis they filed this eviction. They have to say, well, tenant didn't do this, and I have a right to file this to get possession, and we'll look at that document shortly. It's typically either handed to you by the sheriff or it's posted on your door. They also will typically mail a copy to you. They're the same thing. The thing you get in the mail is the same thing as posted on your door. Sometimes it's not posted on your door, or you don't get it until a couple days before the hearing. In some counties, there's a very short time for when that happens, but you got to go to that court date and you got to show up on time if you want the opportunity to tell your side of the story. The vast majority of evictions are filed in small claims court versus district court. So kind of like a Judge Judy sort of courtroom versus a law and order courtroom, if that helps anyone. And they're pretty informal. So it's not really something you have to be too scared about. It's a pretty informal process at the small claims stage. So here is the complaint. If you call into us, this is going to be the document that we want to see, probably the quickest, along with your lease, because this tells us what they're claiming happened. We talk of complaints in terms of boxes: box 1, box 2, box 3, box 4, because there's these 4 boxes. I'm pointing to it, you can't see it, but the circle around those 4 boxes. And the landlord has the burden of proving their case. We'll talk more about that shortly. We're going to start with the bottom, number 4. Criminal activity, it has to be just that. It has to be criminal activity. They can't say, my client's a criminal and I want them out. They have to say, if they're evicting for criminal activity, they have to say, this client is breaking the law in my home. They're using my home to break the law. And it does have to be a specific crime. It can't be something you make up. It's got to be a specific statutory crime. And if that's the case, then the eviction is governed by a kind of a different set of laws. And so it's typically, those are rare. Most people who do something bad in their tenancy, per the landlord, they are going to get a box 3 for breach of lease. So essentially, and again, there has to be a written lease for this, because you can't breach an oral lease because then there's no other term besides I'm paying you this for this. That's all we got for oral leases. And that's when North Carolina's bare bones laws tell you how it goes. But again, so we're talking about written lease here. The lease itself has to say in there that what you're doing is a breach of the lease, and for that breach, landlord gets possession. Let's say that you have a lease and it says pets are not allowed. Okay, and then let's say in that lease it says pets are not allowed. If a pet is found in the apartment, then that's a breach of the lease for which I'm entitled to get possession back. So let's say you get a pet. Let's say the landlord finds out, you admit it, you're like, I got a pet. And they say, okay, well, I'm evicting you for that. They fill this out, they go to court with their lease, presumably, and say, this provision right here says that if they have a pet, then that's a breach for which I'm entitled to get my house back. And they have to prove that you have a pet. So if you haven't admitted it and you're denying that you have a pet, like I don't have a pet, never had a pet, I don't know what you're talking about, then you have a hearing on whether or not you have a pet. Now, breach of lease for which you get possession is different than you just did something bad, but the lease doesn't talk about whatever you did. Okay, so let's say that you have a written lease, and let's say that you have a grill. Let's say you put a grill on your patio, but the lease says nothing about grills. It doesn't say that you're not allowed to have a grill. So you just get to grill because you think you're allowed to have a grill. Well, if the landlord were to take you to court for breach of lease for having a grill, again, they have to have the lease and point to where it says you can't have a grill, and then they have to prove that you have a grill, similar to the pet situation. They're not going to win if the lease, you have to have notice, right? You have to have notice of what you can and can't do. And if the lease doesn't say anything about it, then the landlord can't punish you for that. That's why you should read your lease really, really carefully, though, because there's going to be some things in there that you're not necessarily going to think about. And if the landlord wants you out, they can cling to some term saying you've breached the lease, and for that, they get possession. Let's say, I'm going to give you another example. Let's say that you've got kids that like to draw on walls, as some of us do. Let's say that your kid takes permanent marker and goes all over the wall. Bummer, of course, and something that could cost you. But does that necessarily mean you can be evicted? Not necessarily. Again, so the landlord might, let's say that they're mistaken in this, and they find out that your kid wrote all over the walls, and they're really mad. They're raging mad, and they say, "Get out! I want my property back." They file an eviction, and they check that box 3, and they say, look at the pictures. Look at what the wall looks like. This is unacceptable. I want my property back. They actually would have filed for the wrong thing, assuming there's no lease term that says specifically a child is not allowed to write on the walls. Sometimes they say, you just read your lease. Rarely are they that specific. But in my example, there is no provision that says that. So if they were to take this to court with a complaint for summary ejectment, they could have that picture. They could show how terrible it is. But if it's not something that's in direct violation of the lease, then what they should be filing is a complaint for money owed, not for eviction. So let's say, what they should be saying, if they wanted to go after you for it, is I've got to repaint this wall. It's going to cost me this much. I want them to pay for it. That's not a landlord tenant. That's not an eviction action. That's just a complaint for money owed. So there's a difference between breaching the lease such that the landlord can evict you, get you out, versus doing something bad that you're going to have to pay for, repair or something like that. In which case they could recover money from you, they could charge you for it, but they can't kick you out. Hopefully that makes some sense. Holdover, we talked about that already. Just to quickly, we're talking about a lot of leases are month to month, which literally just say I'm leasing you from 1 month to the next. It's a precarious situation to be in, but it's also nice if you're the tenant, if you're not sure whether you're going to be there for very long. Some lease terms are for 1 year, some are for 2, some are for 10. Most of the leases you see are going to be either month to month or 1 year. If you've got a 1 year lease and you're paying your rent every month, neither you nor the landlord can get out of that lease without some sort of financial hit to you. So let's say you sign a 1 year lease, 2 months later, you want to move out of state. Read that lease, because chances are the landlord's going to try to hold you to the rest of that lease term, unless they can re-rent it. And we'll circle back to that if we have time as well. Also, if you did sign a year lease, I would recommend especially focusing on the notice to vacate time period in there. Like, for example, my lease says that I have to give 60 days notice if I don't want to renew for a year. And a lot of this, I'm saying this because a lot of standard, like long typed out leases say the same thing, because that's the type of lease I have. So usually it's the bottom of the first page, and it says, if you do not want to renew this lease for another year, then you have to tell us at least 60 days before the end of the lease term. And it would work both ways. So for my example is my lease happens to go from January to December. So it's easy for me. Well, around the end of October, or middle of October, I'm, thinking, here's hoping that they extend my lease for another year. It's also when I say to myself, do I definitely want to be here for another year? And I do, and then we don't. Hopefully we're on the same page and another year lease is signed. That's great. If I don't want to renew for January, then I've got to tell them before November 1st, because mine is 60 days. And then of course I've got to pay November, I got to pay December, and I got to be out by December 31st. A lot of leases say 30, a lot of leases say 60. And then there's North Carolina law that in the absence of it, is actually the most brutal in terms of time periods. For example, if you have a month-to-month oral lease, nothing's in writing, and it's just I pay $500 a month and he or she doesn't kick me out, but that's all you got. Then North Carolina law says that the landlord only has to give you 7 days notice, which is brutal on a month-to-month tenancy. So let's say 8 days before the end of the month, this month, which we're still in. Say I got notice today, I'm on a month-to-month tenancy. Say I got notice today, month-to-month oral tenancy. I got notice today that my landlord does not want to rent to me next month. I got to be out by January 31st. So at the same time though, I could give them, like I could just be out and not have to pay for another month as well. But so there's benefits to short-term leases and long-term leases, but just make sure you are aware of what you have. If you signed 1 year, you know what you're on the hook for. Another thing to say that a lot of people don't realize or don't pay attention to is also at the bottom of that first page. It may say if neither party says anything within that 60-day or 30-day period, then the lease will automatically renew on a month-to-month basis under the same lease terms. So let's say me and my landlord, we don't communicate at all. Let's say nothing's signed. So we're going on January 1. There is no new anything signed. Then at that point, I'll be on a month-to-month tenancy. Watch out for month-to-month fees. A lot of apartment complexes will say, if nobody says anything, then sure, you can stay on January 1st, but your rent's going to be $100 and something. Most leases require the landlord to give you a heads up about that. If that's what's going to, well, the law requires them to give you a heads up in the lease about that, if that's what they're going to do, if that's what they want to enforce. So just know when your deadlines are, and communicate with your landlord if you're not sure. Box 1, non-payment of rent. Those are the cases where the landlord is basically filing saying, I just want my money. I don't want the property back. I just want my money. They didn't pay January. I want January rent. And as you can see on that first box, the NC law requires them to give you 10-day 10 days to pay the late rent. So let's say it is January 6th, you have not paid the rent, your landlord texts you or calls you if there's no lease. Let's say there's no written lease. There's always a lease, an oral lease, but there's no written lease. Say the landlord texts you or calls you on the 6th and says, look, your January rent of $500 is due. You need to give it to me within 10 days or I'm going to file. So let's say that communication was on the 6th. Let's say on the 17th or 18th or whatever. I still haven't paid it. And the landlord files what we call a box one, which they check that box and they say, look, my rent is 500 or their rent's 500. They didn't pay it. The most important thing about a box one is that if you are able to come up with the money, or tender, as we call it, they have to accept it because that's what they're saying. They're saying, I just want the money. So if they come up with it, you can't then say, well, never mind, I don't want the money. It does include 126 in court costs, which is the filing fee, and then the sheriff's service fee. So it's not just the back rent. There will be court costs associated with that in order to tender and get it dismissed. Just real quick, a lot of folks are really focused on the other things that are written on this page. For the most part, it's really just those boxes and then what is written. Oh crap, hold on. What is written in the description of breach. Landlords get the rest of it wrong all the time, and they can usually fix it in court. So like if they have the rent wrong, that could be important. Or if they have like the date lease ended wrong, it's really more those 4 boxes. What is the landlord trying to say that you've done? All right, so most of this I've already said. So we talked about the box one complaint. So that's the one that requires 10 days, 10 days notice and 10 days opportunity to pay. So, and a lot of tenants think that they have that right automatically. They think that the law says that no matter what, the landlord has to give me 10 days to pay. When there's no written lease, yes, but a lot of leases, including mine, probably yours, if it's a standard typed up form looking lease, has what we call a default clause, which that when it's written down and signed by both parties, because you sign your lease saying all of that's okay, as I did, that was called a default clause, which says as soon as you're late on rent, I can file for breach of this written lease that I have, because in this lease, in this provision, it says that as soon as they're late, I can file to evict for possession. I'm entitled to possession as soon as they're late. This is why it's really important to read your lease. Not every, like if you have a landlord that just wrote something up real fast, you still have a written lease technically, but it's not going to have, likely not going to have some of these things that, your regular solo landlord would necessarily know. But most standard form leases do have them, which means they don't have to give you any notice. It also means they don't have to accept the rent if it's offered. So these leases are brutal and unforgiving. But if it's, again, read your lease, it'll say something about a reentry clause or default clause. They don't have to give any notice. But again, if you have nothing in writing and you have nothing in writing, you never signed a lease. Now, remember what I said before about leases automatically renewing on the same terms and conditions. So some folks haven't signed a lease for years and they're like, oh, I don't have a lease. I have an oral lease. Well, not necessarily. If you did have a written lease at one point and then it went month to month, like I talked about before, it's possible that the terms of the lease are still in effect, including this default clause I'm talking about. So it's possible that they don't have to give you this 10-day opportunity to cure, as we call it. So if you've never signed a lease, if you know for a fact that you've never signed a lease, then it's got to be a box one. Box 3 for default, for breach, it's only something that landlords can write into a lease. For the tenant has to sign off on it. Otherwise, it's got to be a box one. There does have to be a notice. The notice has to be the right amount of rent, and they do have to wait the full 10 days if they want to win their case. And they can't refuse it. And they can't refuse your rent and then file a box one saying you didn't pay your rent. No, that's contradictory. It doesn't make sense. Tenant can pay all amounts due, including so tender. That's called the tender defense. If you just want to pay and stay, you say, I want a tender. All right, holdover, we talked about that. No landlord is required to continue renting to you or to a tenant after a lease term is up. You could have been a perfect tenant, never late once for 20 years. But if you're on a month-to-month lease, um, or whatever your lease is, at the end of the lease term, the landlord can choose to not renew the lease. They don't have to give you a reason. Um, Now, if they want to get out of the lease during the middle of it, then they have to have a reason and they have to prove that reason. We're not going to go into the specifics of that, but they can't say, well, I changed my mind. I want my house back. Um, you would have to breach the lease for them to get out of it. Or you can, if they want the house back, you might be able to negotiate for some money. But an eviction would not be successful if they just tried to terminate in the middle of the lease term. We talked about the notice already. So in the absence of a written lease, the North Carolina minimum notice requirements you see there are what's in place. So if you've got a year, if you have an oral year lease, so my landlord says, okay, how about all of 2025? You're going to be my tenant. You're going to pay $500 a month for the whole year. So you agree to that. So you know you've got a year lease. It's just not in writing. Then the landlord, in order to be able to get possession back at the end of the year, does have to give you 30 days notice. The landlord accepts rent after the lease ends or signs a new lease with the tenant. The tenant may have a defense to the holdover eviction. Talked about that before. That's when you offer March rent, in my example, hoping that they accept it. Then you're a new tenant, or you're still a tenant for another month. And they would have to give you another notice. They can't accept a rent in March and then file in February and be like, well, I told her in February I didn't want her there anymore. If you accepted my March rent, then as far as I'm concerned, you still want me there. It really is about what's clear to the tenant. The tenant needs to understand what it is the landlord is asking them to do. And if they take my money in March and never say anything again, I have no reason to think they won't take it again in April. So, all right. So I talked about this. We got right of forfeiture, forfeiture clause. Those are legal words that really aren't very helpful. I mean, I guess you're forfeiting your right to be there if you do certain things. Most non-payment cases are brought as breach of lease cases if the landlord can do that. If you have that standard lease, as I said before, and that box 3 is checked and description of breach, it'll say for non-payment of rent. But they do have a burden of bringing out that lease and pointing to where in that lease it says that they get the property back. They don't have to take your money. That's it. They can take your money and let you stay. They don't have to. It's their burden. So they have to bring the law or the lease that says that they can do what it is they're trying to do. But they also don't have to prove very much. All they have to do is have that lease and then prove that you're still there and not paying. There is not a defense to a non-payment of rent. We can talk about habitability in a little bit, but if this is your situation, if you are going to court, you haven't paid rent for, let's say, November, December, January, let's say you're in court in January on a box 3 breach for non-payment, I could tell them everything that's going on in my life. I could tell them why I'm behind in my rent, and I may want to do that because I may want to explain. You have a right to do that. But there's no personal situation that is going to stop that eviction because the magistrates do not have the authority to say, well, I feel bad for this person. I'm going to dismiss it because I think I feel bad for them. That's landlord tenant is pretty straightforward in terms of non-payment. So I'm talking about private tenancies with like a private landlord right now. For subsidized tenants, those tenants in public housing or Section 8 or have a housing choice voucher, or in project-based housing, any sort of subsidized housing, what we call LIHTC, which is low-income housing tax credit. That is also a subsidized program, not public housing, but subsidized in a different way. These programs may have some additional, or do have additional requirements because they are regulated. So they have some additional burdens on the landlord in certain ways, which we will go into. But everything I've been talking about so far is mostly private landlord tenant. Okay, criminal activity. Most of these evictions for us come up in public or subsidized housing, just because that's just what they do. That's just how they come to us, I guess. We rarely see criminal activity, usually because there's just, a breach or something that a private landlord's going to try to hang on to. For subsidized housing, because there's a lot of extra protections, if there is criminal activity, the housing authority might file under this because it allows for an expedited eviction. We don't see a lot of them, but the ones that we do, the first thing we say is, look, is this actually a crime? Like, are you just upset about what they did, or did they actually violate the law and in such a way that threatens the health, safety, and peaceful enjoyment of the other tenants, or is it like threatens the safety or maintenance or function of a public housing complex? It's highly regulated. There's lots of things that they have to show, but I'm not going to get into the weeds of that. We will talk about the bullet points though. A tenant can be held responsible for the actions of other household members and guests. So if you haven't done anything wrong, but you have a guest, and this applies to private too, if you have a guest that comes over and, like, shoots something or someone, or starts selling drugs, whatever it is, the landlord can file an eviction for you, because out the gate, you're responsible for the actions of your household members and guests. Now, in subsidized cases, we will sometimes have situations where the tenant isn't doing anything wrong. They've been a tenant forever, but they've got, a kid or a nephew or someone who is also on the lease but is breaking the law. Again, it's what's happening, where it happened, all of that's relevant, and something legal aid would get into. But for our purposes, if you have a guest that's committing criminal activity, you could very well be evicted for that as well. Partial evictions and conditional evictions. So again, these are mostly subsidized housing contexts, but if there's two people on the lease, as I said, let's say grandma's not doing anything wrong, but grandson is getting into all kinds of trouble, we can ask the court for a partial eviction, which is, look, a non-offending tenant can stay, offending household member it should be evicted, and grandma's fine with that. Grandma's will sign off on the partial eviction and agree that she won't let the grandson back. That's the way to preserve her tenancy. Of course, it's up to the magistrate whether or not they'll do that. Conditional eviction, this would be more of a situation where you're the only person on the lease. Let's say you've got an ex-partner who's banned from the property because they are violent or whatever. Essentially, this is a way to get a subsidized tenant another chance if this guest has caused problems. Then that tenant can say, look, Bob Jones is banned. I will never allow him back on the property. If he comes back on the property, I will call the cops, or I'll whatever. I promise this person's gone. And if the tenant violates that or allows the person back on, then the landlord can go back and say, all right, well, I'm entitled to my eviction now because they broke the condition of this conditional eviction. And again, the breach of lease box and for criminal activity as well, they have to specify why you're being evicted. If you didn't get a notice of it, or if it's not in the complaint and you're in subsidized housing and they just say she committed some sort of crime and I want her out. Again, we're talking about notice. What does the tenant has a right to know what's going on. The tenant has a right to know why you're evicting them, have the right to know specifically what it is you did. Tenant annoys everybody. That's probably not going to rise to the level of a breach. You can be super, super annoying. Every tenant has the right to be super annoying, up to a point where you are threatening health, safety, right of peaceful enjoyment of others. That's the burden that the landlord's got to show is, look, it's not just annoying, it's breaching the lease in this way, or it's a crime per this North Carolina statute. Okay, common defenses. Okay. Retaliatory eviction. This is a tough defense. It really only works if you've been a fantastic tenant, you're paying your rent, you've not given them any other reason to evict you. But let's say the conditions are bad. You paid your January rent, you called code enforcement, they came out, opened a code case, called your landlord, said, this is what's up. And landlord said, they called code on me, and then turn out and try to evict you. They still could have defenses after that. It's a tough one to raise, but it's technically out there. Victim of domestic violence, that so if you're being evicted just because of a DV incident and you are not the aggressor, you will have some protections. There's a law that goes deeper into that. If you are unable to pay your rent because you are a victim of domestic violence, and they file for non-payment, being a victim of domestic violence is not going to be a defense to non-payment. So your let's say that your abuser was on the lease and you've got a 50B and you've got the abuser out, but an abuser's not causing you problems anymore, but come February, you're not going to have enough money to pay the rent because you were both paying it before. Landlord's still going to be able to file an eviction for non-payment of rent, and the DV is not going to be a defense there. DV is really more of a, I want to get out of this lease because my abuser knows where I am and I need to move, and I need to be let out of this lease. That's really more where the DV comes in to help the housing situation. Waiver, as I said before, if you tell me you want me out, tell me a notice to vacate, but you accept my money for the next month, then you're waiving your right to possession at that point. Or if, let's say that your landlord, let's say that, so there's something called an anti-waiver clause. So if you have a form lease generally, and it says something like, well, if landlord continues to accept rent, even though we know of the breach, that doesn't mean we can't evict you for breach later. It has to say that specifically. The pet's a good example of that. Let's say that you have a lease that says pets are not allowed, and doesn't have an anti-waiver clause. Doesn't say pets are not allowed, and doesn't underneath that say, even if we know about the pet, we accept rent, we can still change our mind about the pet later. Essentially, that's what that says. But let's say that your landlord's like, oh, hi, doggy, you're so very cute, I like you. Takes your money every month. And then let's say month 6 of your 1-year lease, the landlord says, oh, you've got a pet. No, I'm going to evict you now. They can't do that because they already knew about the pet and they continue to accept rent, which again that gives the tenant an impression that they're allowed to have that pet, that it is not a breach. But again, the lease can say, just because I accept rent, knowing that you're breaching my lease, I am not waiving the right to take you to court, because that really kind of lets them do that. And if it's a form standard lease that says NAA or Realtors Residential something, probably has an anti-waiver clause in there. But if it's a handwritten lease, probably not. Notice is going to be your most important thing. Was the time, did they give you enough time? Did they wait enough time? Did they put it in writing like your written lease says? Was the amount on the notice right? Like, let's say they gave you a notice that says you owe this much rent, but it's not right. Let's say it's a box 1. If it's a box 3, nothing gonna help you. Box 1, let's say they say that I owed $1,000, but I was like, no, I paid, October rent. And you're saying I didn't. What I didn't pay was November. I paid October. And say they give me a 10-day notice that says I owe October and November back then. That notice is invalid because it's not right. It's got to be the right amount of money. They've got to wait the right amount of time. And if you, within that 10 days, if it's a box 1 for non-payment, and within that 10 days, if you can come up with the money and you offer it to them and they say no, they've screwed themselves over. So keep everything in writing, detailed notes of everything that's going on, in case you do end up in court. Reasonable accommodation, that is, for our fair housing laws, federal fair housing laws and state fair housing laws, say that if someone is disabled and disabled physically, mentally, whatever it is, if someone is disabled and they need an accommodation to the unit so that they can enjoy the tenancy just as if a non-disabled person was living there. The easiest way to do this is, you're a tenant, you rent a house, you're in a wheelchair, you ask the landlord, look, can I install a ramp? Landlord does not have to pay for the ramp. In fact, you can't make the landlord pay for the ramp, but the landlord has to allow you to install the ramp if it's not going to disrupt the house, it's not illegal in some way, or it is not so disruptive that it would reduce the value of the property. If you can take down that ramp when you go and the house looks just the same, they cannot refuse that. They can't evict you because you want the ramp. They can't deny you the option to make the ramp or add the ramp. If they did, and then they filed an eviction, you could potentially raise their failure to acknowledge a reasonable accommodation as a fair housing violation, which gives you some leverage. And then emotional support pets are another common example. If you have a dog or cat, or other typically kept as pet animal, and you have the proper paperwork to show that it's an emotional support animal, then it's not considered a pet. And they can't deny you that because they're saying we don't allow pets, because under North Carolina federal law, it's not a pet. We may or may not go more into that if we have time. Amount claimed is wrong, covered that. Failure to make a demand for possession, skipping over that one. It doesn't, ignore that one. So let's say that you had no clue that your co-tenant was engaging in criminal activity, and you're just like, look, I have no idea. I'm living my life over here. They're living the life over there. They're doing all these crimes. I had no reason to know about it. I have no way to prevent it. This is news to me. Then you can ask for that partial eviction. An unfair and deceptive trade practice, that's not really a defense. Well, it's not a defense. It's a counterclaim. So let's say that the landlord says that they're going to charge you $200 a day for every day that you're late on your rent. That's illegal. North Carolina law says you cannot do that. But let's say they did it. Let's say that neither of you knew that it was illegal, or maybe they did. Who knows? They're charging you $200 and you're paying it. Or even if you don't pay it, if they're charging you that and you have, evidence of that, you might have your own claim against them. And again, it's a counterclaim that might give you leverage in the situation. If they're charging you illegal fees, it's usually illegal fees. Be on time. They're unforgiving. If you are the first on the docket and they call you first and you are not there at 2:01 or 9:01, whatever time, they will start at 2 or whatever time you're supposed to start. And if you're not there, you could be 2 minutes late and you could still miss your case if you're first. So get there. And I also recommend getting there earlier, because if you have the opportunity, if you desire to speak with your landlord or property manager, get there earlier and see if you can talk to them beforehand. Maybe you guys can get on the same page before the case is called. But if you're late, then you're risking judgment for possession and they aren't going to hear the case again. It's going to be over. If you have evidence, if there's something you want to bring to the hearing or something you want to talk about in the hearing, bring it with you. So many times I've heard tenants say, oh, what's in my car? Or I left it at home, when the magistrate asks for like receipt, proof of payment or something. You're gonna have it's your word versus the landlord. Whoever has the documentation is gonna win. Or absent documentation, whoever has the most detailed testimony is gonna win. But if you like my example where they're saying I didn't pay October rent, if I show up at the hearing, I say I did pay October rent, and the magistrate says, well, do you have a receipt? And I say, well, yeah, but it's in my car, or I left it home. Don't be that person. Bring that receipt. Bring that paperwork. If you're talking about something and you don't have the paperwork to back it up, there's no guarantee that the magistrate's even going to listen to you. There's no guarantee they're going to let you go get it from your car or continue the case to let you bring it back. They oftentimes do continue it for the landlord, but they will not necessarily for the tenant to bring what they need. Assume it's going to be a one-shot deal and you've got to bring everything with you that first time. And if you can, print them out, because a lot of courthouses don't let you bring in your phone. And even if you do, it's hard to find stuff, and just print it out if you can. If you've got a receipt, you want to make copies of it. If you've got screenshots you want to show them, ideally you'll print those screenshots out, 3 copies, one for you, one for your landlord, and one for the judge. If you've got a defense and you want to present it, you've really got to bring everything with you. Including a witness. Let's say your mom's going to come with you and testify that you don't own a dog. You've never had a dog. Let's say that sometimes we'll see tenants who have like stray dogs that are running around, and they're, sometimes they get attached to the stray dog and pet them or whatever. If typically the landlord wants you out for some other reason that they can't file an eviction for, and they see you petting a dog, and they might be like, oh, they got a dog, let's evict them for that. But let's say your mom comes in like, look, she doesn't have a dog. I've been over there many times. She's never had a dog. She's allergic to dogs. Shouldn't like dogs. Whatever, as someone with direct knowledge of what the hearing is about can testify. Now, if you were to bring a person that says she's a great tenant, she always pays on time, that's not really going to help. But in terms of your actual defense, if you have somebody that can corroborate what's going on, that's going to be a big help. Okay, so hearsay, everybody's heard about hearsay testimony. So hearsay is when, we'll use the landlord as an example. When the landlord, in this case, says, well, I'm evicting Amanda because her neighbor Bob told me that she has a dog and she's not allowed to have a dog, and my lease says I can evict her for that. Well, that's hearsay, because unless Bob is in the courtroom and there to testify, which he's not, obviously, or he would be testifying, that's not going to work, because I don't have an opportunity to cross-examine Bob. I don't have an opportunity to say, isn't it true that we have stray dogs in the neighborhood? Isn't it true that you've seen this dog a lot? You have the opportunity to confront witnesses against you. So now this doesn't, cops, it's a little different. Police reports oftentimes magistrates will let them in even if a cop's not there. Hearsay rules are not, sometimes they're not as strict with them in small claims court. But if that's the only basis the landlord has, and as soon as that landlord starts saying, well, Bob says, you can say objection, hearsay. You get the opportunity to say objection. Don't slam your arms down though. Magistrates don't like that. Just say objection, Your Honor, hearsay. That person's not here. Now, if the landlord says, I've seen the dog with my own eyes, then that's what we call direct knowledge, not hearsay knowledge. Personal knowledge is another way to say it. So if you're being evicted over a fight with another tenant, and the landlord says, well, I haven't seen any of it, but this tenant told me that she blah, 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 objection. This tenant said objection. Because it's not fair. It's not fair for for the magistrate to take everything that the landlord's saying as fact when you don't have an opportunity to ask your own questions of that person. Tenants should end by saying what they want the magistrate to do. So if you're asking for a dismissal because you have a defense, at the end of your turn, you want to say, I'm asking for a dismissal. If you, at the end of what you want to say, if you don't have a defense, but you want more time, you could say, Your Honor, could you please just continue this case to let me move out, or continue it to let me pay? Look, here's my pay stub. You know, I got this amount in my account today, like just 5 minutes ago, and it covers the full balance. Now, again, what I said before about a box 3 for breach, landlord doesn't have to accept. And if the landlord says, I don't care, they could have the money right, they could have 6 months in advance rent right now. I don't want it. I want my property back and I'm entitled to it because the lease says that. Then, I mean, it's completely up to the magistrate what they do. But sometimes the magistrate will say, look, you know, if you've got a plan to move out and you're going to move it, like, let's say that my mom is there with me, right? Let's say it's a box 3 non-payment, but I brought my mom who says, she's moving in with me at the end of the week. We've got her U-Haul is already at my house. We're taking the last load of blah, 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 or something. And again, this is not a guarantee, completely at the magistrate's discretion. But if you are like this close to moving out or this close to having the full balance of the rent, and you just want to ask the magistrate for an opportunity to work it out with your landlord, an opportunity to move within the next few days, and you've got a specific plan, sometimes, depending on the magistrate, they'll say, okay, I'm going to continue this case for compliance, for one continuance so that you can move out. Now, if money is owed, if there's back rent owed and the landlord is asking for that back rent in their complaint, then that's not as likely. But a lot of these complaints are going to be for what we call possession only. So, and if it says at the bottom of the complaint, it'll say possession only and won't have a number of back rent. It doesn't mean that it's not owed. It doesn't mean that it's not important. Obviously, that's why they're evicting you. But they don't have to prove the amount that you're behind. They don't have to prove they're just like, look, we don't care about the money right now. We just want possession. And again, all they have to prove is that you're there and haven't paid. Now, but if they're asking for money in a complaint, then, and let's say you move out, that's why you're asking for that one continuance for compliance if it's to vacate. Because let's say 1 week continuance. Let's say the magistrate's like, okay, your mom's here. She's saying you're moving in with her this weekend. You know, all they're asking for is possession. We're going to give them 1 week. All right. So let's say the case is continued until next Tuesday. I'm out this weekend. Monday morning, I'm in the property management's office. I give them the key. My mom is there with me as a witness. I give them the key. I go to court on Tuesday and I say, I handed in my key yesterday to Sarah at the management office. ideally Sarah's there. And they're like, yes, everything's fine. But if not, my mom's there with me in court. We were there yesterday. We handed it into Sarah. I have no intentions of going back. I'm out like they asked me to be. Then that should be dismissed because the landlord was asking for possession, meaning of the keys, and you gave it to them. It doesn't mean that they can't come after you for the money later. It doesn't mean they aren't going to report it to your credit. But it means that the actual court action, the legal claim they've asked for, would be dismissed because they've already gotten what they wanted. But again, it's important whether it's a box 1 and they're asking for money or a box 3. A lot of times they're only asking for possession. That's going to be an important thing for you to know too. Okay, so the magistrate's going to issue a judgment if sometimes it's a dismissal, as we discussed, but if you lose the hearing, it's called a judgment. And that judgment there's a 10-day appeal period for both sides, a 10-day waiting period. So nothing can happen for 10 days, legally, that is. So if the landlord lost, they also have a right to appeal within 10 days. So both parties have that no matter what the case is, or what the decision is, you have the right to appeal. So you have that 10-day period. Sometimes magistrates will say, okay, you have 10 days to move out, or you have 10 days to work it out or something, which is really misleading. You have 10 days to appeal the decision. If you do not appeal the decision, it becomes final. The case is over. So if something happens that you would have said at a court hearing, but you don't have the opportunity anymore because the case isn't, that was what appealing is for. If there's something else you want to say, something else you want to introduce to the judge or something, and you don't appeal within 10 days, your opportunity to give that information is over. Now, some folks are like, I don't really care. I'm not going to get padlocked for 10 days. That's great. I don't care about a final judgment. I'm going to move out within 10 days. I'm out. Yay. That's also fine. You are going to have a final eviction on your record if you don't appeal. But there's also no requirement that you appeal if you don't want to. If you want to just move out within 10 days and be done with it, that's fine. If you do not move out within 10 days and do not file that appeal, the landlord has the opportunity at that point on the 11th day, if it's a business day, to request the clerk approval for padlocking. And then the padlocking, which is the sheriff coming out, changing the locks with the landlord, or really the landlord changing the locks in the sheriff's presence, but that's what can happen after that. So that 10 days, hard and fast, 10-day calendar days, not business days. On the 11th day, you will not be able to appeal. You will not be able to pay to stay unless the landlord works with you. That's it. That's the end of the line. Now, so appealing is expensive unless you can file as indigent. And if you cannot file as indigent, which we'll talk about in a second, you have to pay a $150 filing fee to appeal and all the back rent if the back rent is owed. You pay it to the clerk as a bond. So for most folks, that's not, especially if you're being taken to court for non-payment of rent, then that's not going to be feasible. Now, the way to get around that the cost of this is if you qualify as indigent. And there's a form that you'll ask the clerk for along with your appeal form. And if you receive food stamps or SSI, you are automatically, they will approve you for the indigency petition if you bring your photo ID and your food stamps card. You have to bring your photo ID to appeal no matter what. Bring your food stamps card and ask for this form, fill it out, super easy. And then you shouldn't have any issues with that. And what that does, once it's approved by the clerk, is you do not have to pay the $150 filing fee. You do not have to pay all the back rent that is owed. What you will have to pay is prorated rent going forward, and that's called a rent bond. If you think about it, it makes sense. If you want to appeal the magistrate's decision so that the landlord doesn't get screwed over, you have to pay rent going forward. You don't pay it to the landlord, you pay it to the clerk. And that's so the landlord isn't suffering while on appeal. They're still getting their rent paid while you have the opportunity to prepare for another hearing, which is what the appeal is doing. It's requesting a new hearing in district court, which is more formal, like your Law and Order courtroom. Depending on the county, probably a lot uglier than those courtrooms are, though. But anyway, so that also has to be paid with the appeal. So, and it's prorated from the date of judgment. So let's say it's easiest to think of on the 15th. Let's say you go to court on the 15th and you lose your hearing. and you want to appeal. Within 10 days, you will have to go back to the clerk, say, I want to appeal. Here's my name, or here's my complaint with the court file number. I want to appeal. Here's my photo ID. Here's my food stamps card. The only thing the clerk should be asking you for money wise is the rent from January 15th, day of court onward. So the reason why that's easy, 15th, is because it's half of the month. So basically half of the month. So you appeal, you pay half a month's rent to the clerk. You are current with the clerk on your rent bond. So you're waiting for a new court date. Depending on which county you're in, it could be 2 weeks. It could be a year if you live in Guilford County or more. In Greensboro, not High Point. So I would ask the clerk. Some clerks will know how long it's taking to get a new court date. Some will have absolutely no idea. And some will give you straight up wrong information. So if someone's like, oh, well, you can't appeal without, I don't care if you get food stamps. You still got to pay all the back rent. Ask to speak to another clerk or call legal aid. That's not right. If you don't get food stamps or SSI, you can still fill out an affidavit of indigency. You can ask for that from the clerk as well. And it is a side-by-side of your costs or your expenses, your income and your expenses, your assets and your debts. And you just fill it out, be thorough, be comprehensive, be truthful. But if you've got student loan debt, if you've got credit card debt, even if you're not paying on it right now, if it's in forbearance, you still want to put it in the side where it talks about debt. Don't lie about something, but I spend, I don't know, thousands of dollars at the grocery store for my kids, like just so much money. And so when you're putting in your money for food, don't be like $200 a month. I mean, be honest, because it's a lot. It's a lot. Food for the month is a lot. So anyway, that's just my advice on the appeal rent bond situation. If it doesn't sound like it's going right with the clerk, you can give legal aid a call. We can make sure they're following the rules. I would suggest not waiting to the last day in case you do have to put up a fight with the clerk about something. Because again, if it's not completed within that 10 days, there's no opportunity to do it late. Now you do have, again, an opportunity if you appeal and pay the rent bond each month. So for my example, let's say it's February 1st. Well, rent's due again to somebody. So at that point, if you're on appeal, you're going to go to the clerk's office and pay them just as if they were your landlord. And at that point, it's a race to the clerk's office. If you pay on time, like you do on the 1st, late on the 5th, then if the landlord tried to padlock, the clerk would say, nope, we got their money for February. You can't padlock this month. But let's say it's February 8th and you still haven't paid. Well, the landlord, they go and say, okay, I want to padlock now. And they say, okay, well, they haven't paid their February rent bond. You can padlock. So yeah, but let's say it's the 8th, and let's say they haven't asked yet. The landlord hasn't asked the clerk yet. You can race to the court. That's what I call it, a race to the courthouse. So if you were to call me and say, well, I haven't paid my rent bond yet, am I going to get padlocked? Call the clerk, see if a writ of possession, which is the padlocking permission, if that's been issued, and then I'll be like, no, there's no point. But if not, then race down there and pay it before the landlord gets there. So you would have a new hearing in district court. If you do have a defense, you can raise it there. It is more formal. If you really do want to go to court in district court, I would recommend calling legal aid to see if it's worth it. Because there are costs. They can charge you attorney's fees for making them go to district court if the judge decides there was no meritorious defense. It's a new thing. All right, so here's the written padlocking process. That 10-day hard and fast deadline is just that. Once the writ is issued from the clerk, basically the writ is a piece of paper that the clerk signs off and then gives to the sheriff and says, we have approved this landlord for padlocking. The sheriff's the one that schedules it. The landlord and the sheriff together schedule it. They write it down on the writ of possession. They put it on your door saying on January 7th at 8:30, we're coming, January 27th at 8:30, we're coming back to padlock. So that's really the hard and fast deadline of when you've got to physically be out. Now, if you are able to be out and they come there and it looks like you're gone, they'll change the locks. And as far as they're concerned, as far as the law is concerned, you do not have a right to return, but maybe you don't want to anyway, and that's fine. Well, let's say you're still there, you're holding out until the padlocking because you don't have anywhere else to go. At that point in time, they're going to say, look, you got to get out, changing the locks. If you don't leave, then we can arrest you for trespassing. Now, there's a vague North Carolina law that says that the landlord has to acknowledge a request from you within the 7 days following the padlocking if you ask to get in there and get anything out of the unit. So let's say that I've got everything, but not, or almost everything, but not everything out. And the padlocking happens at 8:30 on the 27th. Well, let's say on the 28th, I call, or I email, call my landlord, every type of communication I can think of. And I say, I would like to get back in there on the 29th at noon to get some things. That's all I say. Well, the law says that they cannot ignore that request from me. They can't they can say, okay, that's fine. I will meet you there at 12 o'clock and I'll give you, an hour. I'll give you 2 hours. I'll meet you there every day for the next 7 days. It's completely up to them. It's a very difficult thing to enforce. So I would not recommend counting on that 7 days to move your stuff because aside from straight up ignoring you, if the landlord says that's fine, meet you there at 12, lets you in for an hour, and that's not nearly enough time to get your stuff and says that's it. There's not really, legally it's not gonna be able to help you. And realistically, there's not really anything you're gonna be able to do. So just don't count on that. And a tenant will only have 5 days if the remaining belongings are worth less than $500. Nobody wants to argue over what's $500 worth of stuff. So, 5 days, 7 days, just get your stuff out before padlocking. And if you are unable to, for some reason, immediately upon padlocking, contact your landlord with a specific date and time. It's like your offer, like I'm offering, this is what you got a counter offer. Do you want me to come out a different day, a different time? Like just get the communication started. They cannot ignore you. If they ignore you, then you call legal aid. Okay, I'm super far behind on it. Okay. Landlord's duty to make repairs. All right. As you can see, landlords have a duty to keep their units in a fit and habitable condition. North Carolina law says it. But more importantly, a lot of cities, municipals have an ordinance, minimum housing code, that says specifically what the landlord's supposed to do in terms of maintenance, keeping a home up to code. You can see all of the things that are required. So these duties cannot be waived by the landlord. A lease that says tenant is responsible for all maintenance is not enforceable. If you signed a lease that says you're responsible for all repairs, it doesn't matter. The landlord is responsible for all repairs that fall under the code. If you punch a hole in the wall, the landlord could make you pay for it. But essentially, these are the things that we see in terms of landlord's failure to maintain habitability of a home. In North Carolina, there's no legal right to withhold rent. Like, let's say that your heat goes out and they don't fix it. Technically, there's nothing that says I don't have heat, I don't have to pay my rent. They can't evict me because I don't have heat. You still have to pay your rent. And by I say you have to, I mean that the landlord can file for non-payment and have a basis for an eviction of non-payment, even if the house is in terrible condition, because North Carolina law doesn't say that upon X happening, you don't have to pay rent anymore. Doesn't mean you don't have defenses and doesn't mean you're not going to win your case if you go to court, but it means that you are not automatically protected from a non-payment case because your house is not habitable. And honestly, if you're in an uninhabitable place and you're paying your rent, you could have an affirmative claim against them too, which we can talk about more. Well, we'll talk about it right now. Okay, so rent abatement. It is a counterclaim, meaning it's typically something that actually needs to be filed. Small claims court, not as official, and we'll circle back to that in a minute. So if the landlord does fail to maintain the unit, let's say the easiest is no heat in the winter, like right now. Like if you don't have heat right now, and you go to court, a clerk or a magistrate's going to say, well, I am deciding that they don't have to pay you rent because you don't have any heat. Then you can withhold rent when a judge says you can. But essentially for rent abatement is, let's say that you did pay your rent for like 6 months, even though the conditions were terrible. We're not going to go into the details of terrible, but let's say they're really bad, really, really bad, but you're paying them. And finally, the landlord's refusing to make repairs, even though you told them about it, they've seen it, and they're not fixing it within a reasonable amount of time. You got to give them a reasonable amount of time. What is that? Is whatever your average person would find reasonable. For heat in winter, I'm thinking like a day or two. Now, I'm not saying that they got to get it fixed by then. I'm saying that they got to respond to you. They got to acknowledge the problem. They got to have a plan, because it's very, very dangerous right now with the temperatures. So again, back to my example, let's say that you paid rent for 6 months, but on the 7th month, let's say it's January, it's real cold. You're like, look, I'm not doing it. I got to use this money to go stay in a hotel. I can't do this. And then let's say the landlord is ballsy enough to take you to court for non-payment of rent. Okay, so essentially what you're asking for is you're asking the magistrate to not evict you because you don't owe anything because of the condition of the property is so bad. So it's simple enough. Let's say your heat goes out December 31st, okay? And let's say January is cold. I think it's like the house has to be able to be heated to 55 degrees. I forget specifically what it is, but if it's 20 degrees outside and you don't have heat, a judge is going to find that you don't have to pay the rent. For January, okay, let's say that he went out on January 1st. Okay, just keep it simple. He goes out on January 1st. You don't pay January rent. The landlord files an eviction. You're in court for eviction for non-payment, and you say, I haven't had heat since January 1st. Well, if the magistrate says, well, then if you didn't have heat in January 1st, then I'm going to find that you didn't owe rent as of January 1st, and therefore you don't owe any rent and you're not in breach, and I'm dismissing this. More likely they're going to tell the landlord that you need to get that heat fixed. You can call your local code enforcement if you have one. Some very rural places do not have code enforcement. But if you Google your town, city, and code enforcement, chances are you've got a minimum housing code and a code enforcement office that will send an inspector out for an inspection. This time of year, the dangerous thing about that is that some code enforcement officials will make you leave, especially like if you have small kids and it's 20 degrees outside. Even if you have nowhere to go, they might say, I cannot let you stay here. I'm condemning this. I cannot let you stay here. If you stay here, it's a crime. If you've got space heaters, if you've got some way to keep yourself safe, a code enforcement official is not necessarily going to make you leave if you have nowhere to go. This is just call legal aid if you don't have heat right now. It's just call legal aid. So back to my example, let's say that the conditions have been so bad even before the heat went out on January 1. Let's say for 6 months you had poop coming up your shower drain. Let's say that every time you flush, it overflows. Let's say that there's sparks coming out of your outlets. I mean, I'm talking about real obvious stuff. And you have proof of this. So you bring it to small claims court and you say, look at this, look at this. I shouldn't owe anything. What I'm asking you, magistrate, is to say that I don't owe anything as of January 1 for sure, but also that either I don't owe anything for those prior 6 months and I should get my money back, or I owe less than what the rent is. I think that given the condition that it is, I should only owe $200 instead of $500. I mean, rent is not $500 anywhere. I'm acknowledging that. It's just an easy number. But okay, actually, for the sake of this example, let's say rent's $1,400 a month. And because of the conditions of this place, nobody gonna pay more than like $400 for it because it's that bad. There's no rule as to what the numbers are, which is a weird thing kind of to say, look, Your Honor, I'm guessing it's worth this much. Ultimately, it's the magistrate's job or decision on how much it should be worth based on the testimony. But let's say rent's $1,400. Let's say that I think it's only worth $400, and that at the end of my case, I've proven to the judge, to his or her satisfaction, that it should only be $400 a month. Well, what the judge is going to say is, I'm dismissing the eviction because, for one, she didn't owe you anything, and because of her counterclaim, if you want money from the landlord back, you've got to file something. The magistrate does not to have the authority to order the landlord to pay you something unless you have physically filed something asking for it. A counterclaim for rent abatement is your way of asking the judge, putting it before the judge and saying, I want my money back. Again, call legal aid if you're interested in more information about that. You can also go on our website. There's lots of helpful stuff if you want to file these on your own. If you're already in small claims court for non-payment and habitability is an issue for you, it's really not that difficult to draft a counterclaim just so that you can get it before the judge. It's not before the judge unless you file something, which is hard for tenants to understand and deal with. But at the same time, go to our website. It can tell you how to do it. And we see tenants prevail all the time, but you've got to have the evidence. This is another situation where it'd be really good for you to bring a witness who's been there before. It's like, especially people always talk about mold. Those are tough cases to prove, but what the judge wants to know is how it's affecting your daily life. So it's hard to prove black mold, I'm sick. That's a personal injury. That's not going to be what the judge wants to hear about in rent abatement. It's more, what is this apartment worth? If it's making you sick, obviously you may be entitled to money, consult with a PI attorney or personal injury attorney about that. But for the magistrate on a landlord tenant case, they're going to want to know how it affects your daily living. So let's say that you can see mold all over the walls. Let's say that you clean it and it comes back, or when it rains, you can see like this, I'm sure probably folks listening have this situation. That in and of itself is not really going to be enough. Typically, what I would suggest is, are your clothes wet? Does it smell? Is there mold growing on your personal property? A ton of pictures, witnesses, have people come over, have people smell it, and just testifying that, look, while, they cover it up, they paint over it and all of a sudden it looks fine. But if you're in it, you can smell it, you can feel the moisture, you can smell a smell, you can hear a leak somewhere, think of your senses. Like, what is it? How are you going to prove this to the judge? Now, you can't prove that it's black mold and it's dangerous, but you might be able to prove that, look, fair market value and the way that it is, somebody steps in there, smells it. No way they're going to pay more than $400 a month for this. They may be willing to pay 400 because it's that bad out there, but no more than 400. That's just an example. Now, to file a counterclaim, it does cost money unless you have the indigency petition. So same thing, food stamps, SSI, or the affidavit of indigency. You can get approved for that, and then you won't have to pay anything to file the counterclaim. Draft it, take it to the clerk's office, bring your food stamps card or whatever proof of indigency you have. Bring 2 copies, actually bring 3. The clerk will stamp file all 3. They'll keep the original. They'll give you back one. They'll give you back the second one, which you're supposed to get to your landlord. You have to serve it on your landlord. That's just general information about that. Counterclaims are not as hard as you might think. Affirmative claims, taking your landlord to court when you're not already in court, is harder to do. Not impossible. Check out our website, but it's harder to do. But if you've been taken to court for non-payment and you're like, heck no, call us for one thing. And 2, start getting that evidence together. Take those pictures, label the pictures. I took this picture on January 21st at 3:48. And then take a picture of it when it rains 1 week later. I took this picture on January 28th, January 28th at 2:45. And look at this, look at how much bigger it is. Look at how much worse it is. Create a timeline of events. The more detailed your testimony, the more credit the magistrate's going to give you. It's also something to keep in mind that if the place is really that bad, if the place is so bad that it's possible a magistrate might say, look, I'm not going to find that you owe this landlord any money, but I'm also not going to let you stay here because you just need to move because it's bad. If you haven't paid rent in 6 months, a year, whatever, you've been living through these conditions, but you've self-abated, meaning you just have withheld rent and the landlord didn't do anything about it for a long time until finally they're like, look, you've got to get out. It's not safe. You've got to get out. Magistrate might say, look, I'm finding that this tenant owes you $0 for the past 6 months, but at the same time, I'm granting possession to the landlord because we all agree this isn't a safe place. Just be mindful that might happen. Again, you can call code if it's so bad that you think they might condemn it and tell you to leave immediately, like there's no roof on it anymore, for example. Um, be aware that might happen, but vast majority of times the code's not going to do that. What they're going to do is they're going to inspect, they're going to write up a report noting all the violations of the minimum housing code that they found. They're going to serve, they're going to give it to the landlord. The hearing is going to be scheduled. You do not have to go to that hearing. That hearing technically doesn't have anything to do with you. That's the city versus your landlord. You can if you want to. But that report that the inspector issues is very, very, very important. If you call us, it's the first thing we're going to ask is, have you called code? And two, if you have the report, we want to look at it. Because they're an objective, neutral observer, and their testimony is really important to magistrates. Now, if you're doing this on your own and you don't know how to get to subpoena the inspector to be there, most magistrates are not going to require that the actual inspector be there. If you have the code report and you're doing this on your own, you have the code report, you can talk about it without the inspector being there. I mean, technically it's hearsay, but it's small claims court and they want to know if there's a code report. They want to know. Most magistrates, even if there's no counterclaim filed, will say, all right, let's look into that. Let's talk about that, because again, they're going to want to know just how bad it is if code opened a case. Again, take your pictures, take your videos, get your witnesses, timeline of events. You have to tell the landlord about it. You cannot get rent abatement if the landlord had no idea what was going on. Let's say that you had horrible leaks for 6 months, but you didn't tell them, but you withheld rent instead. Well, if they're like, look, she never said anything. So how am I supposed to fix it? You're not going to win in that situation. You've got to tell them. Tell them in writing, just do it. And keep records of when and how long. Are they ignoring you? Are they responding? Are they sending people? Are they trying to figure it out? Or are they just BSing and ignoring you? Yep, witnesses are super important. And if we are representing you, then we probably will call subpoena the inspector if what they say is helpful. But you don't need a code enforcement report. If you haven't called code, or if your jurisdiction doesn't have one, your testimony, your pictures, your testimony might be sufficient. But if you're in a bigger jurisdiction, we're probably going to ask you if you've called code. So as I said before, these are the damages. So the as warranted, or what we call like the contract value. So your lease is a contract, right? So if you signed a lease saying that $1,400 is what I'm paying, and that's what you're getting, that's what the as warranted value is. But just because you're paying $1,400 a month doesn't mean that the place actually is worth that. So let's say you're paying $1,400 a month, but on the inside it looks like a tornado came through it. We've seen some pretty ridiculous things. So of course, the burden is on you to prove that the contract value is not the correct actual fair market value in the condition that it is. I talked about that before. You may have a beautiful home, but if it does not have heat right now, it is, and it's not through your own fault, its value is zero. And that's because North Carolina law says that. Not a court yet, but North Carolina law will say that. But you've got to have the judge say, yes, I agree. You do not owe rent before you can withhold rent without consequences. Now, in terms of proving what the actual fair market value in the condition that it is, like I said before, there's no answer. There's no chart. It's just, look, I've been renting houses in this area for this many years. This is what I think somebody looking for a house around here would pay. And I would suggest that you recommend a specific number too. And magistrates, like, they don't want to have to do math. If you're like, look, I figured out that it's worth only $400 instead of $1,400, and you know, I've been paying in this much for this long, then I'm entitled to an abatement of this much per month for a total of this amount back from my landlord, what I've already paid. If you have not paid it, then you don't get it back. Obviously, you can't get money back that you haven't paid, but you can say it should be a wash. The value is so bad that from the day I stopped paying, it was zero, like my heat example. And then it can be dismissed because they can say, look, you don't owe anything. And I'm outright dismissing it, but you're not getting any money back because you didn't pay. There's no money to get back. So that's what that limited to the amount of rent actually paid is. Consequential damages, that's an important thing. A lot of tenants have to, in situations like this, have to spend their own money on staying alive, surviving. Not repairs. I typically never recommend that a tenant make their own repairs or pay for, or have anybody else make the repairs without approval of the landlord, because they're going to jump on that and say you're the reason why it's messed up. It was fine until you started messing with it. So don't do that. But let's say for no heat, for example, you got to buy space heaters and your electric bill goes insane after that, or you've got to stay in a hotel. If you are paying rent to the landlord and you're still having to spend this other money, then that is also something you're asking back. It's called consequential damages because it's not rent, obviously. It's not rent you've paid. It's other things you've had to pay to keep the home in a habitable condition. You've had to pay them instead of landlords. So you can ask for those back. You have to prove them. If you're just like, oh, I spent a week in a hotel, I want $2,000, like, it's consequential damages are very, very, very important that you have documentary evidence. If you bought 2 space heaters, keep those receipts, bring them in. Bring in your utility bills, bring in one from when it was normal and one from now, so you can show the difference. Obviously hotel bills, just keep, and if you are making repairs, if you're spending a ton of money on bleach or pest control management things, just keep the receipts. I mean, always keep the receipt, even if you have a great relationship with your landlord and everything's great. Document, document, document. All right. Breaking the lease, as I think I mentioned this before, if you signed a lease for a year, you're on the hook for that year. If you want out, you might be able to negotiate your way out with the landlord, but typically you're on the hook. The landlord does have to mitigate their damages, which basically means they have to try to re-rent it. So let's say I've got a year lease. Let's say I want to get out at the 6-month mark. Right now, landlords can re-rent stuff pretty easily. So they may re-rent it, the second you, or the day after you're out the door. Well, they're not entitled to your rent and that other person's rent, unless there's a penalty fee or something like that, and you're written in your lease. So read your lease. But if you signed a year lease, then you should treat it as though you're going to have to pay out the rest of that lease. They re-rent it. They're probably not going to come after you for that. They may still report it to your credit. Stay tuned for another time for maybe some credit training, but that's not what we're talking about here. As I mentioned before, DV, if you're a DV victim, then it said, this is what the law says, is that if you want to break the lease early and you're a documented DV victim with a 50B, with a restraining order in place, and you give the landlord 30 days notice that you want out of the rest of your lease, you still have to pay rent for those 30 days. But the law says that if those requirements are met, then they're not allowed to hold you to the rest of that lease or demand the rent for the rest of that lease. But again, if that's your situation, call legal aid, because you have to follow a procedure for that. A tenant can aid the landlord in finding a new tenant. Last line. Well, yeah, I guess that's true. The landlord can't just sit on it and not try to re-rent it and then sue you for the rest of the 6 months. They're not going to get anywhere with that. Security deposits. So security deposits, it's important to remember that, like, you could act like that money doesn't even exist until after you move out. You can't not pay your last month rent and say, but you have my security deposit. They'll still take you to court for non-payment, because the security deposit is not meant for that. It is meant to be held in the event that basically a tenant trashes the place or skips out on rent. It's easier to think of like a horrible tenant in this situation than what you may be is like, if a tenant trashes the place and the landlord has to use that $1,000 security deposit to fix it up. Now that's what that's for. Even if you know that the place is going to be in great condition and you don't pay that last month's rent, it doesn't matter, because they don't know that money is not for that. Now let's say you leave it in perfect condition and you're only 1 month behind, and essentially your landlord's gonna be like, all right, I'm gonna keep that for that month. The important thing to remember is that there is a law in North Carolina that says specifically what landlords are supposed to do. And that is, after you return possession, the landlord has to give you, within 30 days, have to give you an initial accounting of that money. So typically they will give you a full accounting. So within 30 days, they have to at least say, okay, we looked at the house. Our initial assessment is we're withholding this from your security deposit for these reasons. This is what this is going to cost. This is what this is going to cost. And within 60 days, they have to either give you the final accounting or do return whatever they said based on that 30-day accounting. they cannot just ignore you, and they cannot just hold on to your security deposit. Even if you owe it, if even if you don't think you get it back, they cannot ignore you. The law allows you to, or says that they waive that if they don't do anything in terms of communicating with you about your security deposit. So normal wear and tear cannot be deducted. I mean, that's just going to be picked apart in court if there's a disagreement over that. So we would recommend take pictures of everything. You should do that initial walkthrough if you can. When you move in, take pictures of everything that's already that way before you move out. In case they try to blame you for something that was already there. But in the event, when you're moving out, take a picture of every single room. Take a picture of something if it was there before, take a picture of it and be like, this was there before. Because in the event that the landlord tries to withhold your security deposit, you want to take them to court, which again, go to our website, you can get some information on that. You want to be able to prove that not only did they not respond to you if they ignored you, but these are the reasons why you should be entitled to the full amount back. Also, okay, so like I said before, if you lose in small claims court, you get a money judgment for, I don't know, $5,000. They have $1,000 of your money. Technically, they're supposed to reduce that debt by $4,000 using your security deposit. And when I say reduce it, I mean in terms of what they're showing as owed, or if in terms of your credit, or what they sue you for. Well, if they already have a money judgment, then they already have a judgment against you. But the problem with that is you can't be sure that the landlord's actually has that amount correct. If you are worried about your credit, if you're worried about a judgment, if you're worried about the financial consequences of an eviction, stay in touch with the landlord, stay in touch with the clerk. How much is this money judgment? What's the interest on this? The landlord had my security deposit for $1,000. Is it showing that he reduced that judgment by $1,000? It's a lot of work and it's a pain in the butt, but it's not something that happens on its own. You should really watch it. If you've got a money judgment and you want to watch it, you've just got to keep track of it. If you want to make payments to the landlord, if you want it gone, then you can make payments to the landlord and they can file satisfaction of judgment. But again, check out our website for more information on that. Okay, so the other thing to be careful about is, so just because they withheld the security deposit and therefore you should get it back, doesn't mean you might not make things worse for yourself. If you are behind in rent for several months, for example, and you want to take them to court for them not giving your security deposit back, or for ignoring your request for your security deposit, they might file a counterclaim and say, okay, yeah, that's fine, but you actually owe me $5,000. So now I have a judgment against you for $4,000 instead of you just letting it go. So just think about it before you file. Okay. I guess that's it.
If anyone has any questions, you are free to put those into the Q&A box on Zoom or the comment section on Facebook. You cannot unmute in this form. If you have a question, you need to type it in. I am not seeing any questions at the moment. We're going to give it a few moments here just to see if any come in. Just to highlight a couple of things, if you or someone you know has been impacted by Hurricane Helene, I have posted a link to some resources in the chat box, as well as a link to Legal Aid of North Carolina's Eviction Defense Manual, which has some helpful handouts for some of the things Amanda discussed throughout the presentation. It's going to give it just a few moments here to see if a question comes in.
I was very thorough. I probably talked more than I needed to.
Okay, hold on. Again, it needs to be an actual question. Can residents sue for rent abatement? This person, I believe, is in a place that was impacted, I think, by Helene, and there wasn't water for 52 days. How does that work with the rent abatement case?
Okay, so we got to take Helene out of the equation in terms of what I talked about for rent abatement, typically, because Helene was not the landlord's fault. Landlords were largely not prepared for it. So it's not going to be a conventional rent abatement. Now, from what I've heard from Helene in that area, water the system was messed up from Helene on the large scale. So a lot of people don't have water because the city of Asheville or whatever does not have water. if it's not, if it's not the landlord's responsibility, you're not going to be able to sue them. So if it's just, I didn't have water because the city of Asheville wasn't running water to my home or whatever, however that works, over there in the pipes, that's, then nothing the landlord can do about that. It's a weird situation, because for the most part, the West was not really prepared for this. The East, however, is prepared for hurricanes, and we can kind of tell you how things shake out over there. But for Western North Carolina, honestly, what we've been telling folks who are in that situation where it was the city of Asheville, they didn't have water for the city of Asheville, is essentially we're just recommending that folks work with their landlord. Say, look, you know, I realize that I'm on the hook for $1,400 a month for my rent. I don't have water right now. It's not your fault, but this place without water is not worth $1,400. And if I were to leave, you're nobody going to move in without water. So like, it's really best for both of us to work together. I can pay X amount instead of $1,400 until water is up and running. That would be ideal if your landlord will agree to a rent abatement on it on their own. I would recommend that before withholding rent. I think the worst thing you can do is just stop paying rent and not talk to your landlord. Especially because if you do end up in court, a magistrate is going to want to know that both parties acted in good faith and in a reasonable manner as best they could. So first would be like, look, I haven't had water, but I don't have anywhere else to go. Can I pay this amount instead of 1,400? If the landlord says no, we're not seeing a lot of landlords, and we don't expect to see a lot of landlords taking tenants to court for non-payment of rent if they know there is no water. Because the judge is probably going to be like, look, there's no water. Like, they're going to tell you, tenant, that you should leave or find some temporary shelter. But they're not going to say, yeah, you got to pay $1,400 a month, most likely. But you don't want eviction filed. That's the worst thing that can happen, because it's, even if it's dismissed, it's still on there. Your name is still in the system. You really want to try to avoid the eviction filing. Now, let's say, and also FEMA. If you haven't applied for FEMA, look at our website. It tells you everything you need to know about that or where to go to find it. So that's your first resource. Now, if you're, it's really just what the landlord can do. I mean, that's why FEMA is there, because a lot of these places were just are uninhabitable, and it would be more money than it could possibly be worth to rebuild. So they say, FEMA says, here's this money, take it, get yourself in a better situation. If it is the landlord's response, if you don't have water because the landlord didn't fix the thing on their property that they had right to access to and a responsibility to fix, then yes, and you've given them notice and they still haven't done it, then yes, it's rent abatement. But just ask yourself, well, is this a landlord problem or is this a city problem? And just try to work with your landlord to figure out where to go from there. I'm not sure when water is coming back or what people are doing about it, but I know that FEMA does have rental assistance for folks to find better situations. If you can also call, if you're not sure about your specific situation, just call our helpline. We are taking calls about Helene. But I would be hesitant to go after a landlord in a Helene context because they might be just as screwed as you, honestly. But call us if you want more specifics about your situation.
Gotcha. Okay. How does one find out if an eviction has been filed against them?
Great question. Call your clerk of court, your county clerk of court. So yeah, Guilford County Clerk of Court, Mecklenburg County, whatever it is. If you Google Clerk of Court, it'll have, but usually the number that pops up first is the number, and you can say, look, I want to know if an eviction's filed against me. This is my name, and this is my landlord's name. Do you see anything in the system? And it's possible that if it's been filed but not served on you yet, they'll be able to tell you that information. But if one is filed and not served on you, meaning given to you by the sheriff, then while it's been filed, you have not technically been served. But some people want to know a heads up before they even get served with the paperwork if something's been filed. You call the clerk, they'll be able to tell you what's in the system.
Gotcha.
And also, just sorry.
Oh, go ahead.
So back to the rent abatement thing, the requesting a self abatement from a landlord is also fine to do in the situation I was talking about before. If the landlord doesn't want to spend 10K on a new HVAC system or whatever, you don't have anywhere to go. You're like, hey, look, I'm not talking about no heat and 20-degree weather. Let's talk about something else that's not going to get you killed. You can say, hey, landlord, we both know that this is a problem. We both know it. I could stop paying rent, or we could agree to reduce my rent. We could both agree so that nobody has to take me to court and I don't take you to court. We're just going to say, look, we're going to agree that the rent should be reduced by this much. Because sometimes the condition is so bad, the landlord is going to tell the magistrate, look, it's too expensive to fix. I just want them out. And if you don't have anywhere to go, then I would highly recommend asking for them to do that. Now, they may not, but it's something worth doing to avoid an eviction filing.
Someone who I think was on Section 8 or is on Section 8 was evicted for non-payment after the ceiling fell in and has been charged for damages to the carpet because of an animal. And the animal did cause some damages to the carpet, but again, the apartment was flooded when the ceiling fell in. Asking if that would be justification for rent abatement. Before Amanda gets, I will say, if you are currently facing an eviction and you are involved in any type of subsidized housing, I encourage you to call the legal aid helpline, which you see on your screen here, or apply for services online. Anyone who is having any problems with the landlord or a housing authority, please call legal aid.
If it's subsidized tenancy, you jump to the top of our list in terms of being able to use our resources. So in that situation, I would most certainly hope that the tenant would call in. Housing authorities, these slumlords, people be doing some shady things all the time. That, from what I'm hearing, if something happened, a weather event, or if the place finally failed because it hasn't been maintained properly over the years, and the landlord's trying to blame you, which happens, unfortunately, that's not proper. And it's really about, especially if you're subsidized and you've been evicted, you could lose your subsidy for that. So you want to call us as soon as possible. Keep that court case active. If you do have defenses and you don't appeal, for example, if you've already been to court and you don't appeal, then there's nothing we could do about it after that 10 days anyway. But yes, I would encourage someone in that situation to call us.
If the landlord is agreeing to let someone out of the lease early, is there a certain process they should follow?
Get everything in writing. Not officially, but if let's say, yeah, the landlord and tenant, your tenant's kind of like, I don't like this place anymore, it's kind of falling apart. And landlord's like, yeah, I know, but I don't have any money to fix it. And you're in a year lease. Absolutely. You can work something out with the landlord in a lot of cases, and I would certainly encourage folks trying to do that, because the justice system it's usually both sides leave dissatisfied. So try to work it out. Yeah, try to work it out with your landlord. And if you both agree that maybe you just don't want to be landlord tenants with each other anymore, and say, how about I pay February and I'm out. Obviously, you pay February, be out by the end of the month, let me out of the lease. Just make sure it's in writing. Even if it's a text exchange that says, yeah, that's cool, that's fine. It doesn't have to be a formal writing, it doesn't have to be notarized. But if it's in writing that a new agreement, essentially it's an entirely new agreement. You've essentially created an entirely new lease term. If it's in writing, then that's fine. Yeah.
Perfect. Well, I have not seen any more questions, so I'm going to go ahead and say thank you to everyone for joining us today, with a special thank you to Amanda for presenting. If you would like to review anything we talked about today, we have posted a recording of our event to our Facebook page. It will be immediately available. If you can access this recording with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other Listen and Learn presentations, like Amanda mentioned, such as child custody, Medicaid, public benefits, you can do so on our website at legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a good and safe rest of their afternoon.
Stay warm.